Okay, let's unpack this. Welcome to the deep dive, where we sift through, well, stacks of sources, really, to bring you the key insights you need to be truly well-informed.
That's the goal.
Today, we're diving deep into some really big shifts from the Supreme Court. Specifically, we're looking at something totally unprecedented,
Right.
criminal immunity for a former president.
Yeah, it's fascinating, isn't it? The court basically had to tackle this question nobody's ever answered before in U.S. history.
Mm.
And it landed alongside a whole bunch of other rulings that, really reshape things like executive power, civil liberties. We'll be drawing from the court's own words, the opinions, the syllabus plus analysis from top legal minds and news outlets.
Right. And our mission, as always, is to cut through all the noise, all the spin, and show you what these really complex decisions actually mean.
Yeah, not just legally, but like for the future of the presidency itself.
And the courts, and frankly, for you listening right now, expect some surprises, maybe a few aha moments along the way.
Yeah.
Okay, so let's jump right into the big one. The Supreme Court ruling on former President Trump's claim of criminal immunity. I mean, this is genuinely historic, right? The first ever criminal prosecution of a former president for things done in office.
Absolutely historic. The court itself called it a question of lasting significance. And the core of their decision, this was July 1st, 2024, is that a former president gets absolute immunity for certain acts.
Quote, absolute immunity. For what kind of acts?
For actions that fall squarely within his conclusive and preclusive constitutional authority. Think of those as the powers only the president has, no question.
Got it.
Then, for his other official acts, things maybe not exclusively presidential but still part of the job, he gets at least presumptive immunity. We can dig into what that means.
Okay, presumptive. And the third category.
And then, crucially, for any unofficial acts, things done outside the job, maybe as a candidate or private citizen, there's no immunity at all. Zero.
All right, so three buckets. Absolute, presumptive, and none. But how did the court actually, start sorting acts into these buckets? And it sounds like they left some sorting for later.
That's exactly right. It's complicated. Let's start with the absolute immunity part, the stuff that's completely shielded.
Okay.
The court said actions taken within the president's exclusive sphere of constitutional authority get this absolute shield. Their examples were things like the pardon power, they actually mentioned Lincoln using it, and the power to remove executive officers, like firing a cabinet member.
So how did that apply directly in the Trump indictment? Which charges did the court say, nope, absolutely immune?
Well, they pointed specifically to discussions former President Trump had with Justice Department officials, about investigating alleged election fraud, and also his threats to replace the acting attorney general if he didn't sort of go along with those investigations.
And why was that absolutely immune?
Because investigating and prosecuting crime is considered a quintessentially executive function. The president's in charge of that constitutionally.
Okay.
They said he has exclusive authority and absolute discretion there. Same for the power to remove top officials like the AG that's seen as a core presidential power. And here's a really key part. The court explicitly stated that even if the investigations were, say, shams or done for an improper purpose, it doesn't change the president's exclusive authority to initiate them.
Wow. So motive doesn't matter for that absolute immunity category. Even if it was done in bad faith, if it's a core power, it's shielded.
Pretty much, yeah. That's a very strong protection.
Okay, so that's absolute immunity. But then you mentioned presumptive immunity for other official acts. How's that different? And what makes that tricky?
Right. So moving beyond those, like, core exclusive powers, we get to presumptive immunity. This covers official acts that are sort of on the outer perimeter of the job. Yeah, as long as they're not manifestly or palpably beyond his authority. Basically, if it looks like part of the job, the presumption is immunity.
Okay, presumption is immunity. Unless.
Well, here's where it gets really interesting and maybe frustrating for prosecutors. The court said, when trying to figure out if something is official or unofficial, courts may not inquire into the president's motives.
Wait, say that again? No looking at motive.
Correct. And an act doesn't become unofficial just because it might have violated some general law.
Okay.
So the default is immunity, and you can't use alleged bad intent to strip that away easily.
That seems huge. How did they apply that presumption then? Did any specific conduct fall into this category but still need more review?
Yes, exactly. They looked at former President Trump's alleged attempts to influence the vice president about the January 6th certification.
Ah, okay.
They said, look, given their roles, president and VP talking about this stuff was on its face, official.
It sounds like there's a but.
But they sent it back down to the district court for further assessment, remanded it.
Why send it back if it was official?
Because the VP's role on Jan 6th isn't actually an executive function. He presides over the Senate count as president of the Senate. That's an article legislative role.
Ah, interesting distinction. Legislative, not executive.
Precisely. Congress has passed laws about that process, and the president doesn't have a direct constitutional or legal role in that specific certification process. So the lower court now has to figure out if prosecuting Trump for trying to influence that specific legislative adjacent role would improperly intrude on executive functions. It's quite a needle to thread.
Okay, so that's complicated. What other conduct did the court basically say, lower courts, you figure out if this was official or unofficial? Seems like they kicked a lot down the road.
They really did. A whole range of other alleged conduct got sent back for classification. This includes former President Trump's interactions with state officials and private parties.
Like trying to convince them about election fraud or the whole alleged fake electors scheme.
Exactly. Trump's side argued this was all official part of ensuring election integrity. They even brought up President Grant sending troops back in the day to make sure electors got certified.
But the government's view is completely different.
Totally different. The government called it campaign conduct. They argued the president has zero authority to organize slates of electors. The states do that. So the lower court needs a fact-specific analysis there.
Okay, what else needs classifying?
Also, former President Trump's conduct around January 6th itself, his tweets, his speech that day.
Is a presidential speech always official?
Usually, yes. A president speaking publicly is typically seen as official, using his, quote, extraordinary power to speak. But the court acknowledged there might be contexts where he's speaking unofficially, maybe more as a candidate or a party leader, not as president.
So how do you tell the difference?
It requires, according to the court, an objective look at the content, form, and context. Again, not easy. Lots for the lower courts to chew on.
Definitely sounds like it. So amidst all this classifying and remanding, what arguments did the court just flat out reject?
Well, they firmly rejected Trump's argument that he couldn't be prosecuted unless he was impeached and convicted by the Senate first.
Right, the impeachment prerequisite argument.
Yeah, the court said the impeachment judgment clause in the Constitution just means prosecution can happen after impeachment, not that it must happen first. So that argument failed.
Okay, and they also rejected the other extreme too, right? The idea that a former president gets no immunity whatsoever.
Correct. They rejected the government's broad claim of zero immunity. The court seemed worried that even just the possibility of a lengthy, maybe politically motivated criminal trial after leaving office could make a sitting president, quote, unduly cautious.
So fear of prosecution could hamstring a president while they're actually in office.
That was the concern. That the Constitution does not tolerate presidents being afraid to make tough calls because of potential future charges. They also felt that normal trial safeguards aren't enough protection for the unique nature of the presidency.
And this next point seems particularly impactful. The court said that acts deemed immune cannot even be used as evidence in a trial about unofficial acts, even to show intent or knowledge.
Yeah, that's a potential bombshell for the prosecution. The court's reasoning was that allowing immune acts as evidence, even for context, would basically eviscerate the immunity.
How so?
They argued it would just invite juries to second-guess the president's motives for his official immune actions, which is exactly what the immunity is supposed to prevent.
But not everyone on the court agreed with that part.
No. Justice Barrett, in her partial concurrence, pushed back. She argued this evidence ban could seriously hamstring the prosecution and that standard rules of evidence should be enough to handle any concerns about prejudice. So a real disagreement there on how far the immunity should reach in practice.
So the big picture for you, the listener, is this. For the first time ever, the court has drawn these lines around presidential accountability after leaving office. It's a brand new legal landscape, and it could fundamentally change how much power or risk future presidents face.
Absolutely. This isn't just about one case.
Now, this immunity ruling, obviously huge, but it didn't happen in a vacuum, right? It seems to fit into some broader patterns we saw from the court this term, especially regarding executive power and the court's own makeup.
That's a really important point. Beyond immunity, this past term definitely highlighted several key trends shaping the court's direction, particularly its conservative majority and its view on the executive branch.
One thing that's gotten a lot of attention is the so-called shadow docket. Can you break down what that actually is and why it's become such a big deal?
Sure. The shadow docket basically refers to the Supreme Court handling emergency appeals and other orders outside its main argued cases.
So like quick decisions.
Often very quick, yeah. Sometimes without full briefing, usually without oral arguments, and occasionally even without explaining the reasoning or revealing the vote breakdown.
And the Trump administration used this a lot.
An unprecedented amount. In their first, I think, 5.5 months, they went to the emergency docket over 20 times. That's more than double the number of times the Bush and Obama administrations combined used it over 16 years. It became a go-to tactic.
And they often won on the shadow docket, didn't they? Like that case about nationwide injunctions, Trump v. Casa.
Exactly. That was a huge win for them, decided via the shadow docket. The court ruled that lower federal courts generally can't issue these universal or nationwide injunctions anymore, where one judge blocks a policy across the whole country.
Why did they block those injunctions?
They basically said there wasn't a strong historical basis for them, citing old English court practices. Importantly, in doing that, they weren't ruling on the actual policy at issue in TASA, which was an executive order trying to limit birthright citizenship. They just struck down the nationwide injunction blocking it.
So a ruling on process, but with massive real-world effects. Even a temporary shadow docket ruling can have huge consequences for people, right? Like with deportations or federal employment rules.
Absolutely. Critics argue it encourages the executive branch to try out legally questionable policies, knowing they might get temporary wins on the shadow docket even if the policy is later overturned.
And Justice Jackson raised concerns about who gets hit hardest.
Yeah, her dissent noted these kinds of procedural hurdles often disproportionately affect, in her words, the poor, the uneducated, and the unpopular.
Okay, another area where we saw shifts in executive power was around removing agency heads, wasn't it?
Yes, definitely.
Yep.
The power of the president to remove commissioners of independent agencies. In Trump v. Boyle, the court essentially allowed the Trump administration to remove commissioners from the Consumer Product Safety Commission, the CPSC.
And that followed similar rulings for other boards.
Right, like the National Labor Relations Board and the Merit Systems Protection Board previously.
But doesn't that kind of fly in the face of older precedent? There was that case, Humphrey's Executor, from way back in 1935.
You're spot on. Humphrey's Executor established that Congress could create independent agencies and limit the president's power to fire their heads, usually allowing removal only for cause, like misconduct, not just political disagreement.
So what are the implications of these newer rulings then?
Well, Justice Kagan, dissenting, argued pretty forcefully that these decisions have all but overturned Humphrey's Executor. She worried it's happening with very little explanation from the court and amounts to a slow, permanent transfer of authority from one branch of government to another, basically boosting presidential power over these agencies.
And we have to remember, all these decisions are coming from a court that looks very different now, largely due to former President Trump's appointments.
Absolutely crucial context. He appointed 3 justices in just one term: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. That created the current 6-3 conservative supermajority.
And Justice Barrett is quite young, relatively speaking.
She is. At 48 when appointed, she's the youngest on the court, meaning her influence could last for decades.
Which also changed the internal dynamics, right? Chief Justice Roberts isn't necessarily the swing vote anymore.
Exactly. With a 6-3 split, his vote, which was often pivotal in the older 5-4 conservative court, is no longer pivotal on many key issues. There's also, ongoing debate about whether this group of appointees is more ideologically consistent or fixed compared to past justices who sometimes shifted over time.
And this clear ideological majority has definitely led to some significant rulings in areas often described as culture war issues.
Yes, the term saw several high-profile decisions in that vein. For instance, the court upheld Tennessee's ban on gender-affirming care for minors. That was a 6-3 decision.
Barrett joined the majority there.
She did, and actually wrote separately indicating she might have gone further. They also ruled that parents have a right to opt their kids out of classroom instruction that uses LGBTQ-themed storybooks.
But it wasn't all one way on rights issues, was it? There were some notable First Amendment wins, too.
That's true. Freedom of speech saw some important victories. In National Rifle Association v. Vulo, the court sided unanimously with the NRA, interestingly, represented by the ACLU in that case.
Strange bedfellows.
Indeed. The ruling established that government officials can't use their regulatory power to indirectly coerce private companies into punishing a group because of its political views, a strong anti-coercion principle.
in online speech.
They also protected free speech online, ruled that social media platforms generally have a First Amendment right to curate content, similar to how newspapers edit.
Okay.
And separately, they said that you, as a citizen, can potentially sue a government official if they block you from their personal social media account, but only if they're using that account to communicate in their official capacity. So, nuanced lines there, too.
Okay, so some wins for speech.
Hmm.
But the court also delivered some rulings seen as setbacks for other rights.
Yes, there were definitely rulings that narrowed certain rights or made them harder to enforce. They overturned a lower court's finding of racial gerrymandering in South Carolina, making it much tougher to win those kinds of cases in the future.
What else?
They ruled that U.S. citizens don't have a constitutional right to challenge the denial of a visa to their non-citizen spouse, even if it means the family can't live together in the U.S.
Wow.
And in a case that drew a lot of attention, they decided the Eighth Amendment's ban on cruel and unusual punishment does not prevent cities from punishing homeless people for sleeping in public, even if there's literally nowhere else for them to go.
And Justice Sotomayor dissented strongly on that one.
Very strongly. Her dissent pointed out, quite simply, sleep is a biological necessity, not a crime. So yeah, you can really see the court's conservative majority making its mark across a whole spectrum of American life.
Absolutely.
Yeah.
Which brings us to how people are reacting to all this. Obviously, the immunity ruling got huge attention. Down in Georgia, for example, voter reactions seemed pretty split along party lines, which isn't exactly surprising.
No, not surprising at all. A Marquette University poll back in May, even before the final ruling, found about 60% of voters felt a former president should not be immune for official acts, while 30% thought they should.
And the Trump campaign's reaction.
They called the decision a big win, framing it as necessary to protect the presidency from, political attacks.
But the justices who dissented, and groups like the ACLU, had a dramatically different perspective.
Oh, absolutely. The ACLU put out a statement saying the court essentially manufactured an immunity that effectively turns presidents into kings, calling the court's reasoning baseless.
And the dissents from Justices Sotomayor and Jackson were quite powerful.
Extremely powerful. Justice Sotomayor argued the majority decision makes a mockery of the core principle that no one is above the law. She said there's just no basis in the text of the Constitution or in history for this kind of immunity.
Did she cite any historical examples?
She did. She pointed to figures like Alexander Hamilton and even the Watergate pardon of Nixon as evidence that accountability, not immunity, has been the expectation.
And she reminded everyone about something Trump's own lawyers said earlier.
Yes, a really sharp point. She highlighted that during Trump's second impeachment trial, his lawyers actually assured the Senate that he could be prosecuted like any other citizen for criminal acts after leaving office. So, a direct contradiction there.
And Sotomayor spelled out some pretty frightening potential consequences of this ruling, didn't she?
She really did. She painted this chilling picture. If official acts are immune regardless of motive, what stops a president from, say, ordering SEAL Team 6 to assassinate a political rival, or organizing a military coup, or taking a bribe in exchange for a pardon? She argued the ruling creates a potential law-free zone around the president for official acts.
Just wow. And Justice Jackson shared similar concerns.
Very similar. Justice Jackson argued this new immunity framework makes it next to impossible to figure out when a president is actually accountable. She felt the court had sort of grabbed power for itself, deciding which laws apply to the president and which don't.
And both seemed worried about the future.
Yeah, both dissents expressed deep concern that this decision basically incentivizes all future presidents to cross the line of criminality while in office, because the potential shield is now so much stronger.
It's clear how high the stakes are and how deeply divided the views are. And this intense polarization, unfortunately, seems to be having real-world safety implications for the justices themselves.
Sadly, yes. Chief Justice Roberts himself spoke out very publicly about the rise in serious threats of violence and murder of judges just simply for doing their work. He was unequivocal. Threatening the judges is totally unacceptable.
And there have been specific incidents.
There have. Reports surfaced of things like a bomb threat targeting Justice Barrett's sister in South Carolina. Justice Barrett herself mentioned her youngest son asking her about wearing a bulletproof vest. You see increased security around the court, around the justices' homes. It's a really concerning sign of the times, reflecting the intense passions these legal battles are stirring up.
So when we take a step back from this deep dive, what we've really unpacked today is a Supreme Court that's actively, you could say aggressively, reshaping the balance of power in the U.S.
Yeah, they're drawing new lines on presidential accountability, revisiting the scope of executive power, the independence of agencies, all while navigating this incredibly polarized national environment.
These decisions aren't just abstract legal theory. From the immunity ruling to shadow docket procedures to agency oversight, these will have really profound, lasting effects on how our government actually works.
And how the law applies or maybe doesn't apply to those at the very top.
So what does all this mean for you, the listener?
Well, it really boils down to a fundamental question, doesn't it? In a nation supposedly built on the idea of a government of laws and not of men, how do we, the American people, respond? How do we engage through our representatives, through our own actions, when the highest court grants such unique, powerful protections to the most powerful office in the land?
It's a question with no easy answer.
Definitely something to think about.